Hello, my name is Trey Flournoy, and I'm an attorney with the Bush Law Group. I want to continue our discussion on ensuing loss, and specifically I want to talk about how it applies to insurance policies. The U.S. Court of Appeals for the Sixth Circuit found that an ensuing loss clause serves two purposes. First, the clause reaffirms that what is not excluded is covered, and secondly, the clause establishes that chronologically later in time damage caused by a peril not otherwise excluded remains covered. In another case, Homeowners Choice Property and Casualty versus Mossboons, the third DCA in Florida held consistently. In that court held, if the insured suffered a consequential loss as a result of a corroded pipe, and that consequential or ensuing loss is not excluded under another provision of the policy, then that loss is covered as well. In other words, the insured must show damage that is separate and distinct from the excluded cause of loss. It is important to keep in mind that ensuing loss is covered even when the loss was originally set in motion by an excluded cause of loss. There are a variety of different insurance forms, but the language that you will see for an ensuing loss provision is usually very similar. An example of that language is, we do not insure for loss to property caused by the following described in coverage A or coverage B caused by any of the following. And then you'll see a list of exclusions, and then the policy will go on to say, however, any ensuing loss to property described in coverage A or B not excluded or accepted is covered by this policy. In another form, you may see language that reads, in the event of an excluded cause of loss resulting in a covered cause of loss, the company will be liable only for such resulting loss or damage. And again, the language is different, but you reach the same result because you have an original cause of loss that's excluded, which causes a resulting loss that is covered because it's not limited by the policy or excluded by the policy somewhere else. So, for example, if a homeowner's roof leaks and the intruding rainwater causes damage to the walls, floor, and other parts of the interior of the house, and the adjuster concludes that the leak was due to improper installation of the roof, the insurance company will then deny coverage for the claim, pointing to the anti-concurrent causation language, and argues that the faulty workmanship is what is an excluded peril and directly or indirectly caused the loss. Insurers attempt to avoid coverage by framing the issue as a question of whether an excluded peril had a role in causing the damage. And if an excluded peril did have a role, then insurers contend the loss is not covered. In this example, the negligent installation of the roof played a role in the chain of events that led to the damage. However, the claim is for roof damage to the interior of the house, not cost to repair the roof. And that's a very important distinction because, as we mentioned before in my prior discussion, the defective workmanship is not going to be covered, but the interior resulting damages will be covered. And it's undeniable that the water damage ensued from a covered peril, rain. And we'll get into that in a little more detail in our next discussion.